The Justice Department recently settled a malicious prosecution lawsuit with former National Security Advisor Michael Flynn for roughly $1.2 million. Around the same time, the administration agreed to a nearly $5 million wrongful death settlement with the family of Ashli Babbitt, who was fatally shot by police during the 2021 Capitol breach. And down in Georgia, former White House Chief of Staff Mark Meadows attempted to use a century-old federal law to yank his state election interference indictment out of local courts and drop it into a federal jurisdiction. Before we look at exactly how these mechanisms work, make sure to subscribe to the channel. We dig into the hidden wiring of government to explain how these backroom maneuvers actually operate. People often assume that massive taxpayer payouts or high-stakes jurisdictional maneuvers require a vote from Congress, or at least a public debate. In reality, these actions are executed by a bureaucratic autopilot, completely isolated from legislative input. Up until the mid-20th century, if someone wanted money from the United States government, they had to petition lawmakers directly. Congress manually reviewed and approved nearly every individual monetary claim, a process that eventually consumed half of their legislative time. To escape this mountain of paperwork, lawmakers created the Judgment Fund in 1956. This established a permanent, indefinite account specifically designed to pay out claims automatically, without the need for case-by-case congressional votes. Today, this modern payout pipeline starts with the Department of Justice. If the Attorney General decides to settle a lawsuit, like the cases involving Michael Flynn or the Babbitt family, they strike the agreement unilaterally. Once the DOJ signs off, the request goes directly to the Treasury Department. The Treasury verifies the basic paperwork and remits the payment. Lawmakers are not consulted, and no new appropriations are passed. A system built to save time on routine administrative claims now operates as an open spigot. Based entirely on the discretion of executive agencies, billions of dollars are transferred from the public fisc to private coffers every single year. While the Judgment Fund protects the government's wallet, Section 1442 of the U.S. Code protects its people. Dating back to the War of 1812 and the Civil War, this statute was designed to shield federal workers, like revenue collectors, from being harassed or arrested by hostile local governments. The law provides a powerful legal shield. If a federal employee is prosecuted in a state court for actions taken strictly within their official duties, they can force the case into federal court, where they often have broader immunity protections. Mark Meadows tried to activate this exact statute. He argued that his involvement in the 2020 Georgia election disputes fell under his vast responsibilities as White House Chief of Staff, and therefore, his state RICO indictment belonged in a federal venue. But the 11th Circuit Court of Appeals shut the maneuver down. They ruled that the 19th century text only applies to current officers, not former ones. Furthermore, they concluded that political campaigning and electioneering sit firmly outside the legal boundaries of presidential duties. The executive branch successfully navigated the financial autopilot to clear the Flynn and Babbitt settlements. But in this instance, the judicial branch held the line, strictly enforcing the text of the removal statute and halting the automatic legal shield. Laws originally drafted to process mundane postal worker injuries and protect wartime tax collectors have evolved. Today, they are the primary mechanisms used in high-stakes, partisan legal warfare. But there is a crucial caveat to this entire architecture. The bureaucratic autopilot only runs because lawmakers permit it to. Congress possesses plenary power over the purse. If they want to stop the multi-million-dollar payouts, they can pass laws expressly restricting the Justice Department from settling specific types of cases, or completely prohibit the use of the Judgment Fund for certain claims. They have the same authority over the courts. If lawmakers want to protect former officials from state prosecutions, they can simply amend the federal officer removal statute to explicitly include them. In fact, a concurring judge in the 11th Circuit explicitly urged Congress to do exactly that. The bureaucracy operates with vast independence, and the millions in settlements flow without friction. But the Constitution still places the ultimate off switch directly in the hands of the legislative branch. The architecture to rein in the autopilot exists. It is merely waiting for the political will to flip the switch.